Right. You'll find that that distraction actually will make it feel like the meal has ended and I've now started a new task.
Can you hear me in Perth?
We can hear you, Alan.
Oh, good, good. Thank you, Rob.
On the screen at the back of the room is Alan Robertson, who is the president of the Academy of Law, and you'll be hearing from him very shortly. My name is Ralph Simmons. I'm a member of the group, and there are other members of the group who organised this, Kanaga Damananda and Erica Teixeira, and on behalf of them and of the Academy more generally, and Alan, we do welcome you to this event. I should acknowledge that, of course, we are on the land, the traditional owners of which, the Whadjuk people of the Noongar Nation, and we pay our respects to their elders, past, present and emerging. We're also in a building of some considerable historical significance in this city. There was a plaque, or there is a plaque, explaining that at the front of the building. It's a 1912 heritage building. Sadly, it's probably best remembered, apart from the fact, of course, it now houses an important law school in this state, remembered that at one point it housed the Chief Protector of Aborigines, as he was known, Mr. A.O. Neville. However, his accommodation has been donated by Curtin University to serve those who are seeking to overcome Mr. Neville's work. Now, there's a little bit of housekeeping I need to do. Ladies and wheelchair accessible toilets are located on both floors on the western side of the building, that is to say, this side of the building. Gentlemen's toilets are located in a rather interesting position, it seems to me. They're sort of halfway down the stairs and on the staircase landing. In the event of an emergency, and I'm here carefully reading what I was told, I'm told you must all please walk calmly to the back of the room. You head up the corridor, which is to the right of the stairwell, and exit the building via the door at the end of the corridor on the left-hand side, down the stairs. Once on the ground floor, the exit away from the building is through the gate at the rear of the deck, and my assumption is that there will be the customary burly people to guide you in that enterprise. Lifts are located to the left of the stairwell. Now, I must add this, every judge present or retired would do so. Please, if you have a communicating device, silence it and ideally switch it off. And I'm now about to do that so that I don't violate my own instruction. I was embarrassed at a recent welcome for a colleague on the Supreme Court when my phone went off, and so I was suitably admonished. Now it's my great pleasure to introduce Professor Natalie Skeed, who is the Dean of the Law School at the University of Western Australia and the Chair of the proceedings today, for her to introduce the topic and the speakers. But before that, I should just allow Alan Robertson to say something briefly about the Academy just before Natalie speaks. Alan.
Thank you very much, Ralph. So, good afternoon or good evening, wherever you're listening from, and welcome to this event of the Australian Academy of Law. The title, as you know, is The Narrative Voice in Fiction and the Law, and I think from the identity of the speakers, you're in for a most interesting and fascinating evening. As Ralph Simmons has said, my name's Alan Robertson. I'm the President of the Australian Academy of Law, and on my own behalf, I pay my respects to the Gadigal people of the Eora Nation, which is and to their elders, past, present, and emerging. They being the traditional owners of the land from which I'm speaking to you in Sydney. First, a brief word about the Australian Academy of Law. It was established in 2007 as an independent, permanent national body comprising distinguished lawyers from the judiciary, academia and the practicing profession. Membership is by invitation by the board of directors. The Academy of Law was established because there was no independent organisation that constituted a bridge between the three branches of the profession I've just mentioned, that is, the judiciary, the academy and the practicing profession. So very briefly, the Academy has a number of prizes and awards and scholarships each year. It publishes monographs, it collaborates with other learned academies and legal organisations, and you can learn all about it obviously on its website. Importantly for tonight's purposes, there's an organising committee of the Academy of Law in each jurisdiction, and the Western Australian Organising Committee is very active and has organised and hosted a diverse range of events, both for fellows and members of the public. After tonight's event, and without further introduction from me, you'll hear again, I think, from Professor Ralph Simmons, who'll move the vote of thanks. But I wish to thank him and Professor Erika Tachira and Mr. Kanaga Dharmananda of Senior Counsel, who are the other members of the Academy of Law Western Australia Events Committee, for organising this evening's event and attending to all the time-consuming detail that's involved. And I also thank Curtin University Law School for its ready assistance, and in particular the help of the Business Operations Coordinator, Ms. Bianca Tavak. It's now my pleasure and privilege to introduce tonight's chair, Professor Natalie Skeed. Dr. Skeed is a Professor of Law and Dean at the University of Western Australia Law School. She has a prolific record in research, a prolific record of publications in property, the confiscation of proceeds of crime, equity in trusts, legal education, and well-being in law. Prior to joining academia, Professor Skeed practiced as a solicitor for over 10 years, specialising in corporate finance, commercial litigation, property and securities. Thereafter, she moved from South Africa to Australia, completing her doctorate at UWA, having as its subject, her doctorate, the proprietary implications of confiscations of proceeds of crime legislation. And she's also director of the Perth Centre for Energy and Resources Arbitration. I thank her in particular for making time available to chair tonight's event, because she is not only a fellow of the Australian Academy of Law, the chair of the Australasian Law Academics Association, deputy chair of the Council of Australian Law Deans, associate editor of the Legal Education Review, and a principal fellow of the Higher Education Academy. So as I say, I thank her for making her time available to chair tonight's event. So please welcome with me Professor Natalie Skeed. Thank you.
Thank you, Alan. Hi, everyone. Good evening. Good afternoon, actually, to all of those who are with me together in this room, and good evening to those who are joining us from elsewhere. I am delighted to welcome you together with Alan and Nicholas to tonight's event. I would like to extend a special welcome to those from New South Wales and Victoria who are just emerging from what has no doubt been a very difficult and a very long lockdown. I too would like to add my acknowledgement of the traditional owners of the lands from which each of us is joining this event tonight. For those of us who are in Perth, that is the Whadjuk people of the Noongar Nation. I acknowledge their customs, their cultures, their beliefs, their languages. I acknowledge their untold stories and their silenced voices. And I too pay my respects to the elders past, present and future. And thank you also to Robert Cunningham and his team for allowing us use of this room. as Alan pointed out, this event is one of a series hosted by the WA Organising Committee of the Academy of Law, comprised of Ralph Simmons and Kanaga Dharmananda and my colleague Erica Teixeira. Tonight's event is really very excited for tonight's event. It explores the use of the narrative voice in both fiction and in law, and they're perhaps not explicitly recognised. There's no doubt that in legal writing and legal argument, there can be much improvement and far more persuasion by using the narrative voice. And I'm delighted to welcome both of our speakers tonight, the Honourable Nicholas Hasluck, AMQC, and the Honourable Justice Darren Jackson. Each speaker will speak for 20 minutes, and then we'll have 20 minutes for questions and answers and general discussion. Our first speaker, and I should say that I have read a couple of his works, and so can absolutely confirm that he is very well placed to speak about storytelling. The Honourable Nicholas Hasluck, AMQC, studied law at the University of Western Australia and the University of Oxford. After completing his studies, Mr. Hasluck worked briefly in Fleet Street in London as an editorial assistant before returning to Australia and working as a solicitor and then later as a barrister. He was appointed Queen's Counsel in 1988 and served as part-time president of the Equal Opportunity Tribunal in Western Australia. In 2010, Mr. Hasluck was appointed a judge of the Supreme Court of Western Australia, and he retired from that position, it was in 2000, and retired from that position in 2010. Mr. Hasluck started writing at school and was first professionally published in 1964. He has since published a number of novels, non-fiction, and a range of other literary works. He has served as chairperson of the Commonwealth Writers' Prize, as well as chair of the Literature Board and the Art Gallery of Western Australia. He was made a member of the Order of Australia in 1986. As I've said, having read a couple of his works, I'm very excited to listen to Mr. Hasluck's presentation on aspects of the narrative voice in fiction and in law.
Thank you, Natalie, for that very warm welcome, and let me say good evening to you all, and especially good evening to Alan Robertson, President of the Academy in the Eastern States, and viewers there. Now, time is fairly tight, so I think I'll just go straight to it without any other preliminaries. So I begin by saying this, that to speak of the narrative voice in law and fiction is to be reminded immediately that the legal system is a vast auditorium occupied by a variety of voices, from the cri de coeur of the litigant, defiant or anguished, as the case may be, to the eloquence of an advocate or the magisterial tones of a judge. Each resembles the voice of a creative writer or historian, because what is said is inevitably affected by the style in which it is said. So let me begin by speaking of narrative in general terms. Narrative is a means of imposing order upon or making sense of various events, irrespective of whether they are actual events, as presented in a historical work or a court of law, or supposed events, as in a literary work. The search for coherence inevitably involves a process of selection by the teller of the tale, directed to matters of chronology, crucial facts, connecting threads, and various underlying values. It will never be enough to set out a mere sequence of events. A well-known example of what amounts to a narrative or story was provided by E.M. Forster in his book Aspects of the Novel. The king died, then the queen died. That is not a story. To say instead, the king died, then the queen died of grief, is a story. The extra words of grief not only amplify the chronology, but also bring into play connective threads of causation and underlying values, a sense of what is holding the events together, the pivotal factor that gives meaning to the story. In the Annals of St. Gall, one finds a list of events that occurred in Gaul in the Dark Ages. Quote, hard winter, Duke Godfrey died, flood everywhere, Pippin, mayor of the palace, died, Saracens came for the first time, unquote. This list immediately transports the reader to what appears to be a culture hovering on the brink of dissolution, threatened by flood and famine, random deaths and invasion. Significantly, however, in the absence of a central subject or indications of a beginning, a middle and an end, the list does not amount to what would normally be thought of as a story, a narrative with a discernible meaning. On the other hand, in Albert Camus' work, The Plague, which may be thought to have some relevance to our current situation in the COVID era, the writer's presentation opens in this way, and I quote, the unusual events in this chronicle occurred in 19X at Oran. Everyone agreed that considering their somewhat extraordinary character, they were out of place there, unquote. The tone is less calamitous than in the Gallic list, but the reader can sense immediately from the title, from the tone, and from what is said, that the first few words of the piece have been shaped to form part of a riveting narrative. The events occur in a certain place, details are provided by a narrator, there will be an outcome confirming the extraordinary nature of the events foreshadowed in the opening. All of this will involve getting to grips not only with the surface structure, the sequence of events, but also with the deep structure of the story, the influence of underlying values and crucial incidents. The narrative voice in law is often complicated by the presence of ambiguities and a need for interpretation as to what values are embodied in the operative legal norms. In Rhetoric and the Rule of Law, Professor Neil McCormick recognised that a familiar feature of any mature legal system is an apparent tension between the arguable character of law and the rule of law. Law has an arguable character because for just about any question other than the simplest, it is necessary to think out a view of the legal issue in question that can be presented in a way that is both sound and persuasive. The rule of law, on the other hand, requires that there be a body of identifiable and generally respected law that will govern the dealings of parties to a transaction or dispute. The rule of law within a state helps to secure the value of legal certainty, security of legal expectations, and safety of the citizens from arbitrary interference by the government of the day or by others. The tension between these two important elements of a mature system, the arguable character of law and the need for certainty, means that acts of persuasion call not only for mastery of the legal norms and evidentiary materials, but also for imagination and a certain boldness of approach, qualities accompanied by the questions, addressed in this paper. If there are gaps in the law that can be filled by ingenuity in certain cases, how should this be done? Will the quest for coherence in narrative bring with it self-deceptive consequences, as can happen with any piece of writing in which the author seeks to weave words together seamlessly, winkling out what doesn't seem to fit, striving for pleasing harmony, until the story is reconfigured by an element of aesthetic truth? To put it another way, is the process of shaping the narrative voice in law, with a view to providing order and coherence, accompanied by a risk that the legal norms otherwise applicable to the matter in hand will be transformed along the way, consciously or subconsciously, to suit the demands of the narrative or the jurist's style? Is there a danger that the rule of law's respect for certainty and objectivity will be distorted by rhetoric? According to the jurist Thomas Hobbes in Leviathan, quote, "Rhetoric has no role in the discovery of truth. Its only role is to spread what is thought to be the truth through vivid prose and graphic images," unquote. Now, it emerges from discussion to this point, after these preliminaries, that the tension between the arguable character of law and the rule of law does allow for change. Adjustments to the legal scene can be effected by robust judicial rulings within the traditions of the common law, quite apart from explicit reforms backed by governments or law reform commissions, which are carried into effect by statutory provisions. Consideration of the narrative voice in law as a vehicle for change brings me to a fine, thought-provoking work by the well-known Australian writer Gideon Haigh, a book called The Brilliant Boy, Doc Evatt and the Great Australian Descent. Haigh's biography covers the life and times of Dr. Herbert Vere Evatt, 1894 to 1965, as a scholarship boy, a talented barrister in the 1920s, a member of the New South Wales Parliament, a High Court judge for a 10-year period from 1930 to 1940, Attorney General and Minister for External Affairs in the Curtin-Chifley governments in the war years, a leader of the Labor Party in Canberra in the 1950s, and eventually a short term as Chief Justice of New South Wales. The focus of Gideon Haigh's book, however, is on the way in which Evatt's personal and political inclinations are arguably reflected in a number of his judgments. It emerges from Haigh's appraisal that Evatt, like Lord Denning, harboured a robust view of the judicial role. He saw a place for himself in the righting of wrongs. The biographer draws attention to some remarks made by Evatt upon stepping down from the High Court as follows, and I quote, "There are many problems of legal right and wrong in which precedent or authority must coerce the court so that no legal development is possible. But there are very important branches of jurisprudence which are not to be regarded as closed legal systems, and which I myself have always regarded as capable of further development and adjustment to the changing needs of modern society," unquote. Cases chosen by the biographer to explore this theme include Chester and the Council of the Municipality of Waverley, decided in 1939. In that case, the High Court held by majority that the respondent local council was not liable in negligence for the nervous shock suffered by a mother as a result of seeing the body of her 7-year-old son recovered from a water-filled trench which the council had dug in a public street and negligently failed to render safe. To a mother, of course, the death of a son and related grief means more than the death of a queen. The Chief Justice of the High Court, Sir John Latham, dismissed the plaintiff's claim in a judgment expressing views shared by other members of the majority. His statement of the facts was brief. He moved quickly to the law applicable to a claim for damages based on negligence. That is, Lord Atkin's dictum in Donoghue and Stevenson, the famous snail in the ginger beer bottle case, in which it was said, well known to you all, that you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. Put shortly, a duty of care is owed not to the world at large, but to your neighbour, as restrictively defined by Lord Atkin. This principle, enunciated in 1932, had not yet been fully explored when Mrs. Chester's claim was dismissed. In Chief Justice Latham's opinion, and I quote, "A reasonable person would not foresee that the negligence of the defendant towards the child would so affect a mother. Death is not an infrequent event, and even violent and distressing deaths are not uncommon. It is, however, not a common experience of mankind that the spectacle, even of the sudden and distressing death of a child, produces any consequence of more than a temporary nature in the case of bystanders, or even of those close relatives who see the body after the death has taken place." Unquote. Justice Evatt began his dissenting judgment with what scholarly lawyers later described as, quote, "an elaborate and dramatic recitation of the facts," unquote. He was obliged to do so, Evatt contended, because the facts were insufficiently set out in an earlier judicial statement concerning the plaintiff's reaction. He sought to enter the mind of the mother, Golda Chester, a penniless Polish Jewish woman with limited English, in this way, and I quote from Evatt's judgment. "Late in the afternoon, it was suggested by someone that Maxie, the plaintiff's child, might have fallen in the water. Coming with her husband to the side of the trench, the plaintiff was at once beset with fear at the sinister significance of the trench, especially when one of the searchers was unable to plumb the depths of the water. She was tortured between the fear that he had been drowned and the hope that he was either not in the trench at all, or that if he was, a quick recovery of his body and the immediate application of artificial respiration might still save him from death. During this crucial period, the plaintiff's condition of mind and nerve can be completely understood only by parents who have been placed in a similar agony of hope and fear, with hope gradually decreasing. Even after the finding of the body, an attempt at artificial respiration was made and abandoned only after expert lifesavers had worked on the child's body for some time." Unquote. Evatt's biographer says of these passages that the judge offered Golda Chester the voice she was denied by having to speak in her second language, thus uniting her with other mothers, perhaps even Evatt's own mother, who had lost sons at the battlefront in the Great War, in the experience of the agony of hope and fear occasioned by a child in peril. To universalise Golda Chester's predicament, Evatt next did something even bolder, deploying lines of verse by William Blake, which included a passage, quote, "the trembling woman pressed with feet of weary woe," unquote, to portray sufferings of the kind he had described. Evatt then went on to cite several passages from the novel Such is Life by the Australian writer Joseph Furphy, in which the horror of a child's disappearance is skillfully evoked. In the end, not surprisingly, Evatt found that the plaintiff's claim to an award of damages was sound in law. His dissenting voice, of course, wasn't sufficient to dispose of the majority's reasoning that led to a dismissal of the claim. Evatt's biographer sums up by saying that some observers remained critical of Evatt's approach, characterising his literary references as obtrusive and unnecessary. Gideon Haigh then proceeds to a very careful analysis of the precedents and legal principles concerning nervous shock claims. Time and space available to me weigh against a full review of his analysis. Suffice it to say that the High Court in Gentian Coffey, 1984, many years later, revisited the relevant issues. The Chief Justice of the Court in Gentian's case, Sir Harry Gibbs, made some observations that bear upon a central characteristic of legal reasoning I mentioned earlier, that is, the tension between the arguable character of law and the rule of law, and the need for balance in responding to the respective considerations. Chief Justice Gibbs said this, and I quote, "In forming its judgments in such a matter, the court is not at large or free to indulge its own individual notions, but must be guided by existing legal principles and by analogies that may be drawn from decided cases. On the other hand, the court is not necessarily constrained to follow earlier decisions when they appear to be out of accord with contemporary principles. For example, the decision in Chester, which cannot be justified either on the ground that the shock in that case was not reasonably foreseeable or on the ground that the requisite proximity was lacking, should no longer be followed," unquote. Justice Dean was equally direct. He said the judgment of the majority in Chester's case, quote, "had not worn well with time," unquote, because it was out of accord with advances in medical knowledge and human experience. Evatt's conclusion was plainly to be preferred. There were a number of complex issues to be determined in Chester's case. Nonetheless, with the benefit of hindsight, it seems that Evatt's attention to the deep structure of the narrative in that case, underpinned by appeals to human nature and related literary sources, proved to be time well spent. By carefully shaping style and structure, the narrative voice in that case was rendered memorable with an enduring effect. Gideon Haigh closes his book by saying this of Evatt's judgment, and I quote, "By reaching us as people, it reinforces faith in justice," unquote. This was a powerful ending to a well-researched book. But judicial officers and practising lawyers will still be left with some crucial questions of the kind mentioned earlier as to the nature and influence of the narrative voice in law. Is there a danger in emotive cases that the balance between the arguable character of law and the rule of law will be tipped in favour of rulings shaped by a robust judicial credo and a riveting narrative voice? Is there a risk that the cautionary words of Chief Justice Gibbs in Gentian's case, weighing against the use of individualistic notions in the doing of justice according to law, will be diluted or displaced by rhetoric as to what must be done by the judiciary in order to meet the demands of changing times? There have been recent cases in Australia which bring the issues canvassed in this paper into sharp focus. Cases in which courts are being urged to follow a lead supposedly provided by prominent voices in the media, cases in which a clamour of moral outrage in the wake of sexual allegations is followed by a search for guilty parties or even scapegoats. It seems to me that in cases of this kind, in which initial outrage, investigations of one kind or another, and related legal proceedings get jumbled up in the public mind, advocates and judicial officers will have to use greater care than usual in reviewing the style in which claims are presented to and resolved by the courts. The structure and style of the narrative voice, as we have seen, can sometimes affect not only the verdict in a particular case, but the shape of the legal norm in question. Time will tell whether the changes made are for better or for worse. Let me conclude by simply saying that I deal with issues of this kind at greater length in my recently published work about the challenges and vagaries of judicial life, called Bench and Book.
Thank you for really demonstrating, I think, how the narrative voice can provide order and coherence and persuasion to an argument. Our second speaker tonight, the Honourable Justice Darren Jackson, will present on the use of narrative in argument and judgment, very closely related, of course, to the first topic. Justice Jackson graduated from the University of Western Australia with a Bachelor of Jurisprudence and a Bachelor of Laws with honours in 1991. He practiced in Perth as a commercial litigation solicitor in 2010 when he was called to the Western Australian Bar. His honour held positions on the Education Committee of the Law Society of Western Australia and the Competition and Consumer Committee of the Business Law section of the Law Council of Australia. He served as a director and chair of Francis Burt Chambers and was appointed senior counsel in 2016. In 2019, his honour was appointed to the Federal Court of Australia and continues to serve on that court. Thank you, Justice Jackson.
Thank you, Natalie. I too would like to acknowledge that tonight I have the privilege of speaking from the land of the Whadjuk people of the Noongar Nation, and I pay my respects to their elders, past, present and emerging. I'd also like to, before I begin the paper, acknowledge with gratitude the work that my research associate Sam Hagan did on the research for the paper and for his very helpful comments on drafts of the paper. I'll start the paper by asking a fairly broad question: what is the law? A simple answer to that question would be that it's a collection of rules. They are what the law is made up of. A slight extension of that simple answer is to say that the law also involves the application of those rules to the facts. That may match your intuition. It's an account which prioritises a view of lawyers as reasoning machines. Lawyers identify rules, they identify facts that are relevant as a matter of logic to the application of those rules, and they derive an outcome from the reasoned application of the rules to the facts. The facts and the rules are like building blocks which can be constructed in the shape of a syllogism or some other logical form to produce an outcome. I suggest that many would find that account of the law uncontroversial, even trite. But as Nicholas Hasluck has just shown us, there is another way of looking at the law, not as a collection of facts married together by the logic of rules, but as a web of stories. So one way of looking at a trial, for example, is to understand it as a formal arrangement of narratives. After all, every participant is telling a story, and they do it in a conventionally ordered way. Pleadings, or at least statements of claim, are a form of stylised narrative. Counsel will probably give a narrative of the case in opening, sometimes a detailed one by reference to documents. Then come the witnesses. What are they doing if not telling stories? Then come closing submissions, which hopefully will have some narrative form in them. And finally, there's the need for the judge and perhaps the jury to develop their own narrative about what happened. While we can't peer into the mysteries of the jury room, in the case of a trial by a judge alone, that narrative will make its way into written reasons and become the definitive story. Definitive, that is, until it's appealed. And then the story of the case may be written again, and battle may be joined over yet more narratives, including stories about what actually happened at the trial itself. It's unsurprising that the court process, which is at the heart of the legal process, is saturated with narrative in this way. After all, stories are persuasive. Professor Robert Ferguson, whose interdisciplinary scholarship had roots in both the English department and the law school of Columbia University, suggested that human beings are driven to tell and listen to stories by a narrative desire, which is in turn driven by passion for meaning. And the American scholars Daniel Farber and Susanna Sherry have described what they call a unified critical viewpoint on the legal system, which holds that, quote, persuasion must take place through the use of stories, which can operate at a deep level of mindset construction. But it is possible to make an even stronger claim than that, a claim that facts or events have no existence outside a narrative. That is, they are not separate things. They can be seen rather as nodes in a web of relations. The relations can be temporal, they could be causal, or they may take other forms, such as relations of meaning or similarity. But they take their meaning from their relationship with each other. So, as the Yale literary scholar Peter Brooks has said, narratives do not simply recount happenings, they give them shape, give them a point, argue their import, proclaim their results. And Nick has just made a similar point this evening when he has observed that narrative not only amplifies the chronology of events, it connects events and gives them meaning. Now, most practising lawyers understand that instinctively. The lawyer who eschews narrative coherence risks making no sense at all. That was the fate of the defendant who was lampooned by the magnificently named Theophilus Parsons, who was Chief Justice of Massachusetts from 1806 to 1813. Said Parsons, a plaintiff brings an action against a neighbour for borrowing and breaking the iron pot in which he cooked his dinner. The defendant says that he never borrowed any pot and that he used it carefully. Also, that the pot was broken and useless when he borrowed it. Also, that he borrowed the pot not of the plaintiff but of somebody else. Also, that the pot in question was the defendant's own pot. Also, that the plaintiff never owned any pot, iron or other. Also, the defendant never had any pot whatsoever. Some of us may well have seen more contemporary pleadings which bear some resemblance to that. So, of course, we all understand that a narrative thread can be a way of avoiding that kind of literally nonsense. But the building blocks understanding of the law, which I described at the beginning of this talk, is not a straw person. As Nicholas Hasluck has just described, a commitment to the rule of law, including notions of fairness and equality before the law, requires that generalisable principles, capable of application to a wide variety of different factual situations, are able to be derived at some level of abstraction. That seems to bring with it, quoting again Professor Brooks, the law's general assumption that it solves cases with legal tools of reason and analysis that have no need for a narrative analysis. And so, for example, the National Judicial College of Australia teaches an approach to judgment writing which holds that judgments should be organised by reference to an analysis of the issues, issue by issue, rather than by any single narrative thread. Indeed, there can be a distrust of narrative in the law. The Yale law professor Harlan Dalton said, "When a story is well told, I park my analytic faculties at the door. I suspend judgment rather than employing it." To say that a person is telling stories can, of course, be to imply the person is embellishing or even fictionalising. So the Canadian scholar Andrew Bricker has depicted narrative as both omnipresent and precarious in the law. He says storytelling might be everywhere, but it is equally forever and perilously on the margins of legitimacy. None other than Alan Dershowitz made a sustained attack on the legitimacy of narrative in the trial process in a paper called Life is Not a Dramatic Narrative, which he delivered in 1995 to a symposium at the Yale Law School. As contestable as Dershowitz's standing has become since then, his complaints in 1995 were trenchant. He took as his starting point Anton Chekhov's well-known piece of literary advice: if in the first chapter you say that a gun hung on the wall, in the second or third chapter it must without fail be discharged. This, he claimed, Dershowitz claimed, was an example of a drive to false coherence, a teleological view of reality to the effect that every event has a purpose and a meaning. For Dershowitz, and I quote, Life is not a purposive narrative that follows Chekhov's canon. Events are often simply meaningless, irrelevant to what comes next. Events can be out of sequence, random, purely accidental, without purpose. If our universe and its inhabitants are governed by rules of chaos, randomness, and purposelessness, then many of the stories, if they can be called stories, will often lack meaning. Human beings always try to impose order and meaning on random chaos, both to understand and control the forces that determine their destiny. This desperate attempt to derive purpose from purposelessness will often distort reality, as indeed Chekhov's canon does. So Dershowitz agrees with Jean-Paul Sartre when he said that when you tell a story about life, although you seem to start at the beginning, in truth you start at the end. Lawyers at least must resist the temptation to impose order on chaos in that way. Otherwise, they risk confusing fact with fiction, and so they can endanger the fact-finding process. According to Dershowitz, human experience cannot be cabined into the structure of narrative. I think Dershowitz's point is well made as far as it goes. As Nicholas Hasluck has just noted, the quest for coherence can lead to deceptive results. We are all prone to see faces in clouds. But I want to suggest that if advocates or judges in legal practice were to embrace Dershowitz's aversion to narrative, then they would be giving up at least 5 things that are of fundamental importance to the law. The first I've already described, simple comprehension. It may be that from the perspective of a criminal defence lawyer, which of course Dershowitz often was, the aim is to demonstrate that the apparent coherence of the prosecution's narrative is false, so that under a barrage of logic it disintegrates into reasonable doubt. But other perspectives simply cannot do without narrative as a way of transmitting meaning. The basic human drives I've already mentioned mean that prosecutors, plaintiffs, judges, juries, and in truth most defendants, have no choice but to embrace the telling of stories as the vehicle for the persuasion and explanation that is demanded of their roles. The second attribute of narrative which is essential to the law is context. This stems from the first attribute because placing things in their proper context is essential if they're to be understood. But it goes beyond that. It's about fidelity to lived experience. It's reflected in the approach which Justice McHugh exhorted in Butcher and Lachlan Elder Realty, of examining conduct which is said to be misleading or deceptive as a whole, in light of the relevant surrounding facts and circumstances, not in isolated parts. Because the flip side of illusory coherence is the presentation of facts removed from the context in which they're embedded. The relations between events, which show them in their true aspect, can thus be lost. The third essential attribute of narrative is its concreteness, its specificity. A story can only ever be a representation, a simulation of lived experience, but it's capable of capturing much more of that experience than any abstract syllogistic argument ever will. Stories reinsert details which can be left out of more general statements that are tailored to the logic of the legal principle involved. The contrast that Nick has just described between the judgments of the majority in Chester and Justice Everett's powerful dissent is, of course, a vivid illustration of that. The fourth essential attribute of narrative is its ethical dimension. Anyone who's heard a parable or has read a story to a child knows that narrative is not just a carrier of information, it is a carrier of values. Professor Robert Cover, in an influential foreword to the 1982 term of the Supreme Court of the United States, put it this way, quote, "In this normative world, law and narrative are inseparably related. Every prescription is insistent in its demand to be located in discourse, to be supplied with history and destiny, beginning and end, explanation and purpose. And every narrative is insistent in its demand for its prescriptive point, its moral." So while lawyers do not answer purely ethical questions and apply those answers directly, the legitimacy of the law depends on the extent to which it embodies the values of the society it serves. To discard narrative is to attenuate the ethical dimension of the law. The result would be a system at risk of floating free from the foundations of its legitimacy. The fifth and final thing that we would lose if we were to walk away from narrative in the law would be the small matter of the common law itself. The doctrine of precedent is, or at least should be, about comparing the narrative before the court with the narratives in previously decided cases, so as to determine whether there is enough relevant similarity so as to dictate an equivalent result. When counsel submits that the case before the court is on all fours with a previously decided case, she is saying that the stories are the same. So, Dr. Bricker calls the invocation of precedent in legal opinions an almost archetypal act of formalised storytelling. Narrative, he says, enables what he calls the cognitive pull of precedent. Closer to home, Chief Justice Quinlan, writing before his appointment to the bench, referred to the common law's narrative tradition as a dynamic, quote, conversation between the new story and the old stories. He described the common law as, quote, thick in the sense of contextually rich, rather than thin in the sense of abstract. Hence, as he says, we remember, for example, that May Donohue's drink on the 26th of August 1928 was bought for her by a friend, that Giovanni and Cesare Amadio were in their kitchen when they executed a guarantee in favour of their son in 1977, that Marie Whitaker was apprehensive about her upcoming surgery in July 1984 and asked questions incessantly, that John and Brenda Miller didn't care much for cricket. So, for those reasons, I suggest to you that narrative is part of the law's DNA. The answer to the concerns that Dershowitz raises is not to discard narrative, but to take its chronological aspect seriously. It may be that the job of counsel is to start at the end, both the end of the story and the end the client wants to achieve. But that is not the job of the judge. Judges should start at the beginning and build their account of the case from there. While any narrative involves selecting some facts and discarding or ignoring others, the selection should be informed by the imperatives of chronology and causation, not by the need to reach a predetermined goal. And it should be alive to the need for texture and context, which includes a refusal to gloss over inconvenient facts or to sand them down until they fit the rest of the story. Approaching the matter that way can be a kind of what's called decision hygiene, which is a term which was coined by Daniel Kahneman, Olivier Siboney and Cass Sunstein in their recent book Noise, A Flaw in Human Judgment. It describes a set of techniques which are designed to minimise cognitive and other distortions, such as confirmation bias. Taking chronology seriously is akin to a method that those authors call linear sequential unmasking, which has been widely adopted in forensic laboratories, and by which investigators in those labs are provided with relevant information at staged intervals in order to minimise those kinds of distortions. To bring the discussion back to the subject of argument and judgments, I hope I've reminded practitioners of those crafts why they should not lose sight of the importance of the narrative form. That is not just because telling a story is more persuasive, although it is. It's also because using narrative keeps submissions and reasons for decision in touch with some of the deeper virtues of our system of the law, which I've tried to sketch briefly here. In a sense, the oppositions inherent in the discussion I've just outlined, that's oppositions between the specific and the general, the concrete and the abstract, are false, or at least they're not oppositions if they are seen through the lens of a true narrative. That's because stories do not just recite the facts of an event, they show what an event means. In that way, a good narrative will embrace both the general and the particular, the abstract and the concrete. It's capable of communicating both broad themes and values and the nuance of specific lived experience. This paradoxical relationship of the specific and the general was captured as long ago in the following passage, which comes from Aristotle. Lack of experience diminishes our power of taking a comprehensive view of the admitted facts. Hence, those who dwell in intimate association with nature and its phenomena are more able to lay down principles such as admit of a wide and coherent development, while those whom devotion to abstract discussions has rendered unobservant of facts are too ready to dogmatise on the basis of a few observations. Chief Justice Alsop described a similar interplay between abstraction and lived experience in his patron's address to this Academy delivered last week. I do hope my Chief Justice won't mind me comparing him to Aristotle. I'll close with one last quote, and this is from the Russian film director Andrei Tarkovsky. While he's speaking of what he calls the artist, I suggest that what he says is also opposite to the lawyer and certainly to the judge. A phenomenon is recreated truthfully in a work of art through the attempt to rebuild the entire living structure of its inner connections. And not even in cinema does the artist have freedom of choice, as he selects and combines facts from a lump of time, however thick and extensive that lump may be. Reality is conditioned by a great many causal connections, and the artist can only grasp some part of these. Moreover, the more he aspires to a realistic account, the greater his responsibility for what he makes. Sincerity, truthfulness and clean hands are the virtues demanded of him. Thank you.
Thank you, Justice Jackson, for a wonderful presentation. We do have 15 minutes. I'll add a few onto that for general discussion, questions and answers. I know I might abuse my position as chair. I couldn't help but think as you were, as both of you were speaking, that yes, Chester is a stark illustration of the arguments, but another more recent and stark illustration is Cobalt, where we have, on the one hand, a chronological list of facts and issues, and in a minority judgment, a far more cohesive, historical, rich exploration of the events.
Yes, I chuckled then because I actually had that example in an earlier version of the paper, and I agree, Natalie, without, of course, wanting to comment on who was right or who was wrong in the result. I must admit that when I read through the judgments from start to finish, it wasn't until I actually got to Justice Edelman's judgment right at the end when I thought, oh, so that's what was happening. And it did make a difference to the perspective, I think, with which one views the issues in the case, definitely.
Robert, did you have a question?
Oh, look, thank you so much for the presentation. It's really fascinating. And I found it very poetic, the way in which David brought to mind John Keats' idea that poets are the true legislators of the world, which I think is also this theme of literature. I guess with the Australian Academy of Law, it's the bridge, as was indicated at the beginning, between the three different aspects of the profession. I guess I'm interested in the thoughts of the panel as to the different roles of the bench, the profession itself, the academy, in relation to this theme of narrative fiction in the law. One of the things that's been happening in the academy, for example, in recent times is the rewriting of judgments from an academic point of view. So taking one of the points I think that you quoted, Nicholas, along the way was wondered about the role of imagination in the context in which I'm referring, and again how that might relate to the three different aspects of the legal academy.
Well, just a quick comment on that one. And sidestepping it to some extent, but I think I found Darren's paper enormously stimulating, and particularly this kind of conundrum with Dershowitz at the heart of the thing, because I don't really understand Dershowitz's stance that narrative can be disregarded for all the reasons Darren explained and was partly implicit in my paper. I mean, narrative must be fundamental to law and to thinking generally. I mean, most philosophers, I forget who said it exactly, said, well, one has to see life steadily and see it whole. And that's how thinking is mostly done. But coming back to your point, in terms of the imagination, you see, I think Dershowitz's example of Chekhov, and of course it is true, that's a famous example, Chekhov says if you have a gun in the first act, it's got to go off or be fired in the last act. But I mean, I would characterise that not as something, some fundamental characteristic of narrative, but simply a matter of dramatic technique. And it's true that if you're working with a work of the imagination, techniques and motifs of that kind are constantly in play. But practicing lawyers wouldn't be interested in that very much, because you can't quite, if you've got some gun in the situation you're establishing, you will determine as a matter of verifiable fact whether it went off or not. You're not going to sort of play with it or conjure with it. So I don't quite, I think Dershowitz is sort of leading us astray slightly by using an illustration of that kind to try and reinforce his case. So that's a rather oblique way of responding to your question.
Yes, I mean, I would tend to agree. Dershowitz was useful for my purposes as, I suppose, an irritant to bring out the ideas. I think he is being a bit naughty by using what is clearly a piece of advice to somebody constructing a drama as if it's somehow going to be applied in legal practice. I suppose, being fair to him, he might have been saying that whether or not that is the intention behind what jury advocates do, he might have been saying that juries, those poor, much maligned and essential institutions, juries can't help but think in terms of those dramatic tropes that they've imbibed, perhaps not from Chekhov, but maybe from NCIS. But I still think that at the end of the day, as Nick has said, the real question you would ask Dershowitz is, well, what's the alternative? And that's why I suggested that it's, in some sense, it was spoken like a true defence lawyer, where your job is to demolish, well, your job may well be to demolish the prosecution side rather than put anything up in its place. Sorry, Rob, I'm not sure if our answers have taken us quite a fair distance from your questions. Imagination, you wouldn't want, I don't think anyone, my initial reaction is that you wouldn't want imagination to have any kind of overt role in the serious business of legal submissions and legal argument and, of course, judgments. Of course, fidelity to the facts is the main, is one of the main virtues. I suppose, though, you could make an argument that imagination in the sense of being open to and appreciating possibilities is important. It's important not to close your mind. It's especially important for the judge. That's why I stress trying to find a way of approaching the task which delays that moment where you say, okay, I think this is what's happened, until the last possible moment.
I just add a footnote to that, because Darren was touching on competing narratives, and I suppose one act of imagination that comes to mind is in a criminal trial, if there's a defence of alibi, the prosecution is saying the defendant was there, he was in the bar, he stabbed the barman who failed to give him the martini he wanted or something, and the defendant is saying, no, I wasn't there at all, I was home watching TV with my wife. Now, there's two competing narratives, and the jury will be asked to decide eventually, but one of them may just be a complete act of imagination. In fact, so there is an instance where imagination is coming into play in the actual legal process.
And a footnote to your footnote, which I read in one of the papers I was reading for this. So that kind of alibi is apparently very common, or at least was at a certain time in the United States, and the defence lawyer who was writing this paper was bemoaning the fact that the prosecutor always asked one question, which is, so the defendant says, I was at home watching television with my wife that night. Of course, the wife says that too. And then the first question in cross-examination is, and what were you doing at that time the night before? To which the answer, well, I can't remember that. I can't remember. And it just destroys the narrative.
Just getting back to the Dershowitz point, in terms of a civil plea, the requirement for relevance makes that almost inevitable. So if you put in a plea, and this is what you obviously have, if you put in a plea that a gun was left in space, because that needs to be relevant, we can't not hear about the gun again. The gun is probably going to be, needs to be relevant to whatever happens, that it's a subject of the course of action. So, again, I can't understand why Dershowitz says that.
Again, to try to be fair to him, and obviously I couldn't lay out his whole argument in this paper, you may not be surprised to hear that a lot of what he was saying was informed by his experience in the O.J. Simpson trial.
No surprise at all.
And so, without endorsing the points he's making, I think what the point he was trying to make was this: there was evidence that Nicole Brown Simpson had been beaten by O.J. Simpson several times while they were married, and he was trying to draw the analogy that, well, when the prosecution says that, that's akin to saying, well, here's the loaded gun on the wall. It doesn't follow that OJ actually killed her in the third act. He made the mistake of taking on Professor Catherine McKinnon, who some of you may be familiar with, who was speaking at the same symposium, who pointed out that, yes, so because the point he was making was, well, millions and millions of women are regrettably the victims of domestic violence, but only a very, very small percentage of them are murdered. So there's no statistical connection between the two. But McKinnon pointed out that, well, yeah, but how many women who have been murdered and had been beaten by their husband were not murdered by the person who beat them? So, to be honest, his argument fell apart. But
We have time, I think, for one more really quick question. And Bill, you had your hand up earlier.
I'm not displacing.
Or can I go you?
I'll surrender.
And there is another one, Bill. You also.
But I'm wondering whether there's not some interesting parallel here between the debates that take place in relation to colonial history and the debate. On we have this issue of the significance of narrative and difficulties of selection and the significance of selection of facts, for example, in the writing of any explanatory history. And of course you have that snooty debate between the analytical historians and narratives. Missing the significance of the narrative historians. And I'm wondering whether there's not a parallel here between the lawyers so concerned about rules and principles and endeavouring to minimise the significance of factual discussion, factual exposition, to which incidentally imagination seems to be crucial as it is in history and life. Only appear to be sensible in retrospect because we impose selection and narrative.
Well, I certainly agree with everything you said. I mean, in some sense, all history is untrustworthy to a certain extent because it depends upon the process of selection. And just as we've been saying here, that may be influenced by some personal predilections of the historian in question and so forth. But of course, the balancing thing is that one awaits a later historian who will challenge the sources and interpretation. But there is very much that dichotomy, I think, yes.
And I think, Bill, the answer to your question is also just yes, from the point of view of how some of the learning that informs these areas has developed historically. There was a big movement about law and narrative in the United States in the first half of the 90s, and that was informed by a lot of people. I've mentioned some literary scholars, but also certainly historians who were getting in on the act and bringing their tools of analysis to legal writing. So there's definitely parallels and overlaps there.
Thank you. We have sadly run out of time, so all that remains is for Ralph to wrap up. Thank you. You'll need that.
And I immediately have an apology for everyone who's online. I forgot my central task, which was to move the microphone to the people asking questions. So there would have been a mystery, I think, for many of those who were watching us online. But can I say on behalf of the Academy how superbly our speakers today, under the skillful direction of our chair, have demonstrated the value of the Academy enterprise. The Academy's enterprise, as you've heard repeatedly, is to bring together the wisdom and experience of the variety of those involved in or otherwise concerned about the law. The organising committee for this event are absolutely delighted that the issue of such a coming together has been what you have seen today. We thank, as I have already indicated, but we do it again, we thank our speakers, our chair, and Curtin Law School, whose physical facilities made all of this possible and whose staff were crucial to the achievement. A mention has already been made of one member of the staff, so I'll embarrass her by mentioning again Bianca's work. She could tell a story of what putting all of this together was about. But I would prefer to follow up on a suggestion Justice Jackson has invited, and to commend to you two films of central significance to anybody concerned about narrative in the law. The first of them is the extraordinary motion picture, The Last Duel. If you are ever interested in what the legal system of mid-1300s France was like, and how it had an issue in trial by combat, which was a matter of great interest to a former colleague of mine at Murdoch, then that is the movie to see. But the other one, which I haven't seen yet, but my son assures me is an amazing piece of work, is of course Dune, which brings together an amazing variety of perspectives on how to run a dusty planet. There may or may not be something in that for all of us. Again, thank you all for coming, your participation. Thank again our chair and our speakers. And there will now be, I gather, light refreshments and, as they say in management circles, networking opportunities behind the door here. Thank you again. I saw him perform at a function in Yale in 1982. We came out spinning chairs.
1982?
Yeah, it was...